Morning, everyone. This is Russell Rucker. I'm here for another constitutional talk. And as we get into the Fourth through Eighth Amendments uh, that encompass the rights of the accused, you know, these amendments were brought during a time of the first Congress, and the whole idea was to write up a Bill of Rights because the states during the ratifying conventions were complaining that there was no Bill of Rights. Though one of the big section of the Bill of Rights has to do with the rights of the accused. You have a right to a speedy trial. You have a right to a trial by jury. You have a right to face your accusers. You have the right to be secure in your person's houses, places, and effects. You got a lot of different things and rules of administering law. But there's something else here too when we get into talking about the accused, and that is the presidential pardon system. Even if you go through court and you're found guilty and you're serving a sentence, it doesn't mean that a president won't come along and pardon you for some reason or another. Maybe he thought the penalty was too harsh, even though there are rules against a cruel and unusual punishment. That's kind of depends on how you define that. And a president might decide that it was too much, it was too strict. Um, Maybe he thinks that you weren't guilty. Maybe you've had some other evidence come forth in the last couple of years that bring doubt upon the case. So even though you were found guilty as a trial, by a jury of your peers, it's still possible that you didn't get a fair trial for some reason or another, or it's found later that a witness lied during court. I mean, how do we really know? But the presidential pardon gives a president a chance to overlook the case and decide whether or not to allow you to be released, or get a lighter sentence, or maybe just get a new trial. So I bring this up because it is an important part of the original Constitution, being from the "We the People" section to the signatures. That's the original Constitution that was voted on in 1787. So in Article 2, Section 2, and he shall have the power, he meaning the president, so the president shall have the power to grant reprieves, pardons for offenses against the United States, except in cases of impeachment. So if you're found guilty of, say, a state offense, then your governor would have the same authority. So you could go to the governor and ask him for a reprieve, or a suspension of the punishment that you've endured, and the same goes with the president of the United States. But as that section states, Article 2, Section 2, about impeachment. So, if you're the president of the United States, and I know this has never occurred, but let's say, for instance, that you were elected as a vice president, the president was impeached, and so because the president was impeached and removed, you become president based on the Constitution and the line of succession. But then you can't take the man who was your running mate and was president, you cannot give him a pardon and allow him to be released. See, if you're found guilty in the Senate and impeached, you can't run for a future office either. So if you were allowed to be pardoned, then you could just run for president again. This is one of the reasons why you cannot have a political decision by a president to pardon his predecessor, or maybe it was one or two presidents ago, but that's not allowed. But if you have a trial and you're found guilty of something, and they say you killed somebody, and later they find out through evidence that that didn't really happen. I mean, today we have DNA evidence. You know, in the last part of the 1800s, they came up with fingerprints and that kind of thing. And so if new evidence arises and they find that you're not guilty, you still have a shot of a presidential pardon. You still get the president to step in if you can get his ear. I think that can become an important step in the process of a judicial system. You know, Article 3 sets up a Supreme Court and inferior courts, and then you have state courts beneath them. And as you go through the system and you're originally found guilty, you can appeal to the next level, the next plateau, per se. And as you work through the system, and eventually, and if you're found that you can't get off for some reason, that you were guilty and they were sure you were guilty, and so you were put into prison. But then a few years later, they find out that, well, he really didn't do it. This other guy did it, or somebody else admits to the crime. You still have a chance to get a presidential pardon and have the whole case removed. Though I hope you get an idea of the importance our founders had for the rights of the accused and a fair judiciary. And think about that for a while. Think about how important a fair judiciary is. You know, sometimes we have a crime that is thought to be horrific and terrible, and the attorneys defending the man are ridiculed. You know, this is not a good thing, because you have to have someone to defend the accused, no matter what the crime is. Because if you stop qualified attorneys from defending an accused because people think that he's guilty, that's not a fair trial. We have to allow people, no matter what they're accused of, to have a proper defense in court. It's the only way we can really get there. It's the only way that defendant has a right to a fair trial. And regardless of what he's accused of, he should have that right. And there should be a fair justice system. And a president should have a shot if he thinks some crimes, or even classes of crimes, that something went wrong at trial, that he should have that opportunity to give out a pardon or a reprieve for offenses against the United States. I want you to think about that for a little bit, and think about how important the rights of the accused are, and the whole idea about fair jurisprudence. And we'll talk again on the next Constitutional Talk. You folks have a good day. Thank you. Bye.